So welcome to another in the series of webinars from the Human-Centric Cybersecurity Partnership. We're very excited about our guest this week. He's one of the original members of the partnership and has been with us in multiple efforts over, I'd say, the last decade or so, and is very well renowned within his field. I'll remind everyone at this point that you can ask questions at any time throughout the presentation. Make sure that you leave them in the chat, and we will get to them towards the end of the hour. So I would like to introduce to you Dr. Florian Martin Barreteau, who is the University Research Chair in Technology and Society at the University of Ottawa, where he leads the AI Plus Society Initiative and the Centre of Law, Technology and Society. His research focuses on technology law, AI ethics, cybersecurity, intellectual property, and shaping policies for a more secure and an inclusive digital future. Today, he'll be speaking on promoting digital safety through whistleblower protection. So without further ado, I'll hand it over to Dr. Florian Martin Barreteau.
Hi, bonjour, good morning. Thank you. Well, good afternoon, actually. Thank you so much first for the invitation to share with you my research today, and for Michael and the team at HC2P for all the logistic and the organization behind today's talk. So for Michael mentioned the title of the talk, and so today the goal in about half an hour hopefully is to share with you some of my research I've been leading with my team under the umbrella of the Human-Centric Cybersecurity Partnership. And yeah, on whistleblower protection, and we're also going to discuss some of the latest digital policy development in Canada, maybe in the US and around the world, and maybe what we could see play in the next election, and in maybe the next negotiation between some countries. And one of the argument I've been making for many years in my research and in my public advocacies is that in the development of digital policies to protect Canadians, we talked about many things, but from cybersecurity to AI policy, we have one major blind spot that has yet to be considered. That is the protection of whistleblowers and public interest researchers to support, secret systems and the responsible development and deployment of AI and other socio-technical systems. Today, our lives are, digital. With my colleague Isabelle Dubois, a few years ago, we published a book with a few colleagues, and the first sentence is, citizenship is now digital, and we're not governed by algorithms. And while, AI and those socio-technical systems are promising considerable benefits, the recent development in those obscure algorithms have raised multiple legal, political, and ethical issues with issues related to the respect of fundamental rights, the protection of electoral integrity and democracy, and also the protection of those brave enough to disclose those issues. And I'm sure you're thinking of a lot of cases with whistleblower within government, but also within Meta for Instagram, like Sophie Zhang and others. And so the deployment of private AI systems across society is causing a shift of power to new structures beyond the control of existing governance and accountability framework. And these new governors, as Kay Klonik called them, bring concerns for democracy and democratic freedoms to the forefront. And in my opinion, years of inactions have facilitated a socio-technical reality where the dominion of algorithms is dictated by the choices of technologists and system architects rather than the collective will and need of society. And it is the same thing for a lot of the cybersecurity policies and system. And this is actually one of the the goal of the HC2P work and team to shift the focus on some of those projects and policy to put back the human and society at the center. And so Today, we have a lack of transparency, oversight, and accountability on how AI systems are developed and how it can be used to the detriment of society. And we've seen this so much last year during like during elections around the world in Brazil, in the US, in Romania. And so this is also reinforced by increasing copyright and trade secrets protection and inaction with respect to anti-competitive behaviors that created a digital ecosystem that is governed by a few players. And we've seen this especially at play, in the US, and especially under the new administration, where like the big tech have basically announced they will team up with the Trump administration to interfere globally in different like democracies, Canada, the EU, and how they decide to govern digital context and how those societies are refusing to just let them do whatever they want in the digital context. And so over the years, several whistleblowers and or former employees unveiled, mass evidence of deliberate malice and harmful choices that negatively impact society. And the failed internal governance models, infrastructure design choices, or the lack of like proper internal feedback loops enabled hate speech, the spread of misinformation, and promoted insurrections. And these shortcomings also have amplified harms to already marginalized community toward like queer people, Black people, indigenous, communities, and also the youth and kids. This is also what Franz Hagens highlighted with the design choices, of Instagram and the feeds and the ads like toward the kids community. But this social technical reality is not and was not inevitable. And governance practice and frameworks, in my opinion, should evolve and must evolve to balance and information asymmetries from corporation towards the public. We have an issue that is first related to information asymmetries and overload when we talk about, AI governance, internet governance, like cybersecurity governance and accountability and transparency. We try several tools for responsible AI or responsible, tech development. One thing is for sure, ethical guidelines and technical standards have so far been quite ineffective, and we need to go beyond this. Some jurisdictions, not Canada, have adopted or proposed complex legal frameworks. And those, legal frameworks are very complex to design and even more complex to enforce, notably due to informational asymmetry. To help with this obscurity, the latest legislative conversation in the EU with like the AI Act, etc., in the US before the Trump administration, and in Canada before prorogation and coming soon to an election, push towards more transparency and documentation obligation to try to open the so-called black box and try to understand and force like those companies to unpack to us what is happening and the kind of choices they made. These requirements are an initial and necessary step toward accountability, and this in some way foster some sort of an oversight. Yet it's very like laudable, but transparency, that kind of transparency isn't without it flows. So first, it offloads the duty of awareness onto society, citizens, and consumer. And we need to be careful to not, create an information overload that would transfer the burden to individuals and offer a kind of get out of jail card to industry. Well, we told you this in a 300-page document. You should have known it's not our fault. So we need to be careful about this. And also, like, second, it kind of really provides useful disclosures, and it often obfuscates malicious practices. They decide what they put in this or not. There is a way to provide information, and the limited information released to meet the beer threshold of the regulatory requirements is often unveiled as a corporate communication exercise, met with red tape, layers of revision by an array of lawyers for compliance purposes, sometimes to make it maybe more clear in the plain language, but often we may lose technical information. And so the recent log area of transparency reports for AI, for privacy, for content moderation, etc., hasn't successfully mitigated the most pressing concern. And don't get me wrong, okay, first point, like we need strong AI regulation, we need strong transparency and accountability standards. But we also need, well-equipped regulators with teeth and auditing powers, and also regulators who have like the staff and the budget to lead investigation and decide sanction, that are like the capacity to go through all of those documentation on behalf of the public, because the public doesn't have the capacity, either technical or financial, as the same as civil society that is underfunded, that was already underfunded, especially in Canada, that is now like in not a very good situation under the current context of like new shift in fundraising and philanthropy. But so in our toolkit for responsible, AI policy, responsible tech, AI development, tech development, and cybersecurity, we need more. We need to empower and protect workers who are familiar with the technical reality and design choices, and those who were at the decision table. I do believe that the future of responsible technology development, responsible AI, will come from adequate protection for whistleblower and security researcher, in addition to everything else we're working on. Whistleblowers are linked to some of the greatest scandals of our modern society. Concerned citizens have disclosed confidential information to the public to prevent or expose political, social, financial, technological, or like health-related wrongdoings. Extensive research demonstrates that whistleblowing in the public and the private sectors is one of, if not the most common ways in which wrongdoing are identified. From Christopher Willey, so the Cambridge Analytica whistleblower, to Frances Haugen and Sophie Zhang, whistleblowers have revealed, the most recent technological scandals, and have shown that disclosure of security breaches, surveillance, and certain activism is essential to protect our digital security and digital safety of Canadians. So whistleblower is essential to reveal those major issues within the tech industry, but they lack protection and take tremendous risk to alert authorities and the public. So in my research, and we have like we did a few reports, a big website, and we have a new paper soon coming out on this. So I've identified policy, legal, and digital literacy gaps for such a protection. Certainly, we need to, there must be a fair balance between public disclosure and the protection of trade secrets, and also of like governmental secrets. Yet, the public interest should trump the financial interest of a few privilege. And legal framework must evolve to better protect the public rather than reinforcing algorithmic power asymmetries through criminal law and trade secrets. So we need legislative, criminal, and civil protection reform for whistleblowers. And very few states and countries provide for such a protection in the private sector. And even when it is often very limited in terms of who is protected and what kind of disclosure is actually protected and to whom. Usually you cannot even go to the public or to to the media. And even when they're like civil exemption, they're often criminal protection. They protect IP and trade secrets that prohibit such disclosure. And Canada is for sure lagging behind in all sector. Even while the lack of protection for whistleblower has been presented as a threat to national security by NCIRA, the Internal Oversight Agency, nothing has been done. So that's interesting. That even the intelligence community have been coming forward saying like, we need whistleblower to ensure, like proper accountability and transparency in the intelligence community. That's something that's interesting, as often national security is used as an excuse to block any advances, especially like within governments. At the moment in Canada, we do not have a general framework protecting whistleblower, and we have an uncertain legal framework that can be inferred from a patchwork of legislation at the federal and provincial levels, with several distinctions between public and private sector. There's been progress in many fields, especially in the healthcare system, over the past years, following like a series of scandals. So like in Quebec, Quebec has been like a leading kind of the on the whistleblower protection side. Sorry, but they like very restrictive in what you can do. The status are like very complex. There is like a few key issues to keep in mind when we think of like the gaps and the limitation of the status. Is often like who is protected in the status is often like just the full-time employee, and that could be an issue for more like within governments who use more and more consultants and occasional employees, or like the public staffers, or some like high level public sector actors as well, like people appointed by governor in council, or like a minister. That kind of thing will not be protected. Same like private sector employees involved in contractual or like secondment relationship with the public sector may not be, well, actually will not be protected. And that's an issue where like there is more and more like public private sector partnership, and there is no protection in the private sector, so that increased concern with respect of the delegation of activities to the private sector, making sure that there is kind of safe ways of blowing the whistle for some of them. And often also when we have a statute and we have very few, and we don't have one level in the private sector, like for the tech industry and stuff, the disclosure are protected only for very specific wrongdoings. It's not something that's general, especially like in the public sector. And for the public sector protection in Canada, the federal level, a violation of the Treasury Board Directive on automated decision making. That is a policy that is supposed to help bring accountability and transparency on the use of AI in the federal public sector. Well, a violation of the policy is not a wrongdoing under that will like someone who blows the whistle about such wrongdoing will not be protected under the federal statute. So that quite problematic when we think of like digital safety, when like a lot of the cybersecurity and digital security rules are not like statutes or like criminal laws, etc., but a lot of policies and directives from treasury boards. So yeah, and then like to whom you disclose is also very like restrictive. There is almost no or very few exception for like public disclosure, going to the media, going to the public, because there is not the proper pipeline inside the government or inside the organization to alert people, and this is usually prohibited. Or when it's authorized, it's very, very strict, and it's only when, a life is in danger. And when we think about like cybersecurity practices and digital safety, how do you define this? What kind of harm could you consider as being like big enough and important enough to allow you to go public? The way the statutes are defined, I would say, in most cases, it would not qualify under the act. And another criteria that is an issue when we have a protection is often like is that an alert, like a disclosure, must be made in good faith. That is a very high standard that even the House of Commons, in a report from 2017, as you see, it's almost like 10 years ago, highlighted that the requirement for good faith should be repealed, and that we should, in lieu, like favor the reasonable belief that the public servant, in this case, in the case of the report that disclose a wrongdoing, should only be submitted to like the standard of reasonable belief to bring forward the claim. Another big thing is anonymity. Like whistleblower-based protection relies on their anonymity. That is an issue because a lot of governmental and parapublic agencies seem to discount that parameter. For example, for years, ISET, so Innovation, Science, and Economic Development, with like other agencies, was retrieving information from whistleblower through unsecured forms. Many authorities, like in the financial sector, were requesting information by email for employees. While like it's well documented, and if you do a bit of research on like the best practices to disclose information, the last thing you want to do is to do it by email. And they don't even flag to people they should use a personal email, a new email, not your work email, when we know that within a lot of organization, email are like flag tracked. If you send an email to the regulator, it's not sent to the regulator, it is redirected to internal teams, because only a few people are supposed to email regulators, and most people don't know that all their work emails are monitored this way for like specific keywords or addresses, and that basically, actually, we may have a lot of employees that try to alert regulators, but the alert never arrived to the regulator for this reason. So that's an issue. And so this is when we have protection, and as I mentioned, we don't really have protection in the private sector. This is an issue, so following prorogation, all of the bills we had in Parliament to bring forward some kind of like digital accountability for AI or for platforms, they all died on the paper order. But Bill C-27 and the AI and Data Act was really silent on whistleblower, which in my opinion was a huge gap when we want to bring more like accountability and transparency and more documentation. And they had like a fake commissioner that was like a high-level public servant within ISED. When the budget was announced, it was a very small budget compared to like the task that this team would have to accomplish. All the documentation and like resources and complaint they will have to process maybe from the public. So that was like a big gap. Another bill that was very interesting and quite good was Bill C-63, the Unarmed Arm Act. At least when I say quite good, part one. Don't quote me on the other part as being quite cool. And well, so the bill was very interesting in the sense that it was not focusing so much on on content, but was trying to bring a systemic approach to online harms and harmful content online by putting on the platform a series of duties and like duty of cares and like up making sure the algorithm were not like amplifying harmful content, etc. So very interesting. And like the regulators at powers and were like an ombudsman to promote digital literacy. So very interesting. But one of the bill's biggest shortcoming was again, in my opinion, the lack of protection for whistleblowers. Well, like when the bill was proposed, we had, we knew that we knew of the issue because of whistleblowers. So it's sad that nobody thought of putting this in the bill, or at least that it was not approved to be in the first draft. So for sure, it is true that the bill would oblige the commission to protect the identity of people reporting observation. So you had this option. But yeah, so it was only the people communicating information to the commission, but the bill was not extended such protection to operators' employees who would have to request anonymity while specifying what could put them at risk. So it was like someone from a company, it was on them to say like, okay, you cannot provide that kind of information on my name because of this. It might put me at risk this way, this way. I don't fully understand, why we needed such a high threshold, and an employee who is unfamiliar with surveillance techniques could put themselves at risk, as the bill did not provide for protection from reprisal by the employer. And in addition, and I will come back to this, there were no exception to provision of from the criminal code that protect trade secrets or like from non-disclosure agreements, and so employees were like still at risk of criminal or civil prosecution for any information that would have been provided to the regulator under the framework. So it has like quite a chilling, or at least it could have quite a chilling effect. So we need to change this, and we need to like also incentivize companies when we have those kind of bills to build internal processes. It is often the case that workers must go public because internal processes failed. Lately, with respect to generative AI or like AI ethics, teams have been disbanded after flagging that the deployment of a model was too early or need to go through extensive validation to avoid harming society, because it was playing against the financial interest of the company. It is well documented. If they have to make a choice, they will choose financial advantage over protecting society. And so stronger internal safeguard and appropriate protection for workers with adequate internal disclosure policies and procedures would facilitate proactive mitigation of harm before deployments. And beyond people within these companies, we also need to work on providing adequate protection to people outside. Most jurisdictions lack proper protection for well-intentioned security researchers to proceed with testing and disclosure of vulnerabilities. More and more now we have bias bounties that are like, learning and building on the long-standing security bug bounties, program in cybersecurity, or like other kind of program that are like aiming at tackling, bias and issues in AI system and platform. This is good, but we need like more of them. And also we need more than this, because they are like in control environments with the agreements and under the control of the companies. We need, for those people, we have the experts, the capacity, the time, and the will to help out society to be able to look at the systems and model that are not willingly open to them. And we need them to be protected when they do so, but also when they want to disclose issues. It is for sure very complex to design, but it's not impossible. Belgium did it for CVDs. And a last point, I see I'm coming to like the end of my time, but a last point I would like to make is that to build a better digital future, we need to limit trade secrets and NDAs, so non-disclosure agreements. We need to limit them by and for the public interest. It was one of the biggest issues that came to light as part of the Me Too movement, and this is again an issue with social technical system and AI system. As more and more public sector activities and tools are covered by private sector terms and conditions and trade secrets, it is essential to provide safeguards for employees and consultants and others under trade secrets or like NDAs. Contrary to Europe, North America seems to be moving backwards on this topic, especially Canada. We need to mitigate such legal impediments, which may also interfere with an individual ability to establish, causation in case of harm if the plaintiff is unable to access property code or other components. So it's not just like an issue that is related to whistleblower. It's to build a case in case of like an harm caused by an AI system. We need to have the possibility to like do that kind of research and unpack this, and it might be prohibited by the criminal code, and we have no exemption whatsoever at the moment. Like in Canada for trade secrets, one of the best / actually worst example is actually that following the adoption of CUSMA that we're talking a lot lately, talking about a lot, Canada was forced to amend its criminal code to provide for protection of trade secrets in the vein of the US Defend Trade Secrets Act. However, contrary to the US statutes, the legislation surprisingly does not provide for any kind of public interest exemption, exception, or protection, while like such safeguards exist in the US. So it's like we copy paste almost like the prohibition, but not the exceptions. And without statutory exception in the criminal code or like amendment to other federal acts, for example, in the public sector disclosure act, like in C27, in C63, and so on. While an employee might be protected when they are protected under reprisal or like civil liability, they could still be subject to criminal prosecution should the information be subject to trade secrets. And it seems very urgent to fix this and to build such an exception for information that might be protected by trade secrets under section 391 of the criminal code. And maybe on the model of like the section 32 that protect against like self-incriminatory statements, etc. So as a result, today most AI system and like systems that are not well designed are basically protected by a veil of obscurity by the criminal code. And so it appears quite urgent to correct this oversight. And so as social technical system, increasingly permeate every facet of our existence, influencing vital aspect of our lives and the very essence of our citizenry, and maybe also the very existence of our country based on some of the comments we can hear from our colleagues, from our neighbors from the south, the call for such protection and such reform becomes imperative and critical for the technological sector. And so hence my argument that for a better digital future, we need whistleblowers and security researchers to be protected both within the public and the private sector to promote responsible AI, responsible security system, and also socio-technical system. Thank you so much.
Thank you for that. That was very interesting, and I'd like to remind everybody that this is the time to put your comments and questions in the chat, and we will get to each and every one of them, hopefully. While we're waiting for people to put them in, and I see them starting to come in, which is wonderful. Just like to ask you, given that we're kind of in a put politely, a dynamic time in terms of politics, how would you like to see these issues be raised as a sort of a voting issue in an upcoming election? Were they to be there?
Yeah, dynamic time, interesting times. We like the term to be polite in a professional setting to qualify what is happening at the moment, and digital policies are like at the center of it. And we know as part of the trade war, they're gonna be like, there is a few claims about like some of the legislative movement that happened in Canada in the past years. But so we're not yet in an election. We don't know when we can have an election, but we know it's coming. It's a question of days before we may see the first platforms. And I would really hope first that digital safety of Canadians and accountability, transparency, the protection of privacy of Canadians, I would hope to see that on all the platforms for all the parties, because this is much needed. And it's not just civil society or academic things. So even the industries, like, please, could we update and amend like the privacy framework? Our system are protected under rules that are like drafted in 1995. That's like a long time ago. It's 30 years ago, way before the data economy or however you want to call it. So that's one thing. And I would hope that whoever will win the election, that they will quickly put forward like a new privacy reform that is much needed, a proper Canadian AI regulation, AI Act with strong regulators, etc., but also with whistleblower protection. I would hope to see strong protection, also like Bill 63, so like the Online Harm Act, and with like a systemic approach to like platform governance and content governance and harmful content. I would hope to see this again, correcting the gaps of the previous proposal with whistleblower protection. And also I would, for many years, we have been promised a reform of the public sector at the federal level, whistleblower protection. That has been heavily criticized by everybody involved except the cabinet. Following all of the criticism, the Treasury Board had put in place a committee to look into this, and even last spring when Minister Anna launched the consultation and the work for the AI strategy, I had the opportunity to like raise this concern, like, oh, but we're gonna be working on this, and nothing really has happened yet. So I would hope for the next government to take this issue seriously, not just for the technological system, but for like all our departments and for like our intelligence community to be able to like safely like raise the the flag to like NCRA or like other regulators. So I think that there is a moment now for them to like take action, especially to protect workers within big tech, to flag to Canadians if some decision are made to impede democratic processes in Canada and harm Canadian democracy. We know that this is gonna happen. We don't know exactly how and when. We just know that it will happen. So it would be good to protect the people who will come forward to help us navigate those complex challenges.
We'll take a question from YouTube. Actually, this one's coming in. How would we assess this issue in the light of institutional corruption, which is increasingly becoming rampant?
A very easy and very light first question. I think so. I think that's also why I'm not sure I will say we have like I will fully agree with the statement, but I understand the statement, and I do think this is why we need to protect, people. And I'm guessing when you're talking about institutional corruption, you've like it's within government. This is why we need to protect them, and this is why initially like we put in place such a framework at the federal or at the professional provincial level. We need to have this in place, but also this is why I think in my talk I mentioned the need to also carve out exemption for some public servant to go to the public, to go to the media in some cases, because we know that unfortunately even they're not well protected, and also there is not the proper pipeline internally, and they may actually be more protected if they go outside, because journalists will protect the anonymity of the sources and will look into this document and provide like maybe more evidence before going forward. So I think this is why we need to work on this to build trust. It's a question of trust from Canadians vis-a-vis the government, and kind of like the technological and but also like democratic ecosystem. They need to know that if something goes wrong, the people will take care about Canadian democracy, and Canadians can go forward without being afraid. And someone oh, it seems overly dramatic. You can just read so many book and stories. They're not like fiction of what happened to whistleblowers, or sometimes just under so many attack and campaign of disinformation or personal attacks and stuff upon them. They will commit suicide, or they in some cases they got killed by others and stuff. But there are so many movies about this, and people are like, oh yeah, it's a movie. No, most of those movies, they build on facts and what happened in history around the world. So that's why we need to protect them.
We'll take some more questions from the audience, but first, I just wanted to bring you back to something you said earlier. You mentioned how even some national security organizations were calling for better protections for whistleblowers. Just curious if you could talk a little more about how whistleblowers aid national security.
Yeah. So we don't have all of the details because it's national security, but it appears in. So it was highlighted in the report from NCRA. So for those who are not aware, NCRA is a federal agency in the complex intelligence apparatus of the Canadian intelligence community that is in charge of that is oversight responsibility toward all of the community intelligence agencies and even groups within within Global Affairs Canada, etc. And there are a few exchange also with the Justice Department that has been unveiled by journalists through access to information that of course heavily redacted. But so one of the findings of NCRA, and I'm blanking for the year, trying to find in which year was this? Let me No, I don't have the year. I'm sorry. But like those interested can contact me. I can provide this. So in one of the annual report, they highlighted that one of the findings that the fact that we may have issues, we may have, like breach or failures or something that is not working in our insurance system, or like, lack of communication between agencies, something going wrong. Nobody's perfect. There might be like, bad behaviors, etc. Because we like proper feedback, loops and like internal mechanism and a protection for them to go for it, to have someone to talk to. We're supposed to have some kind of policies because all of those actors, they're like excluded from the public sector framework. So like same in the forces, we're supposed to have like, a strong framework put in place by the Department of National Defense. As we've seen in the past years, there also have been a few issues within the forces. And so yeah, so N0 argued, and it was surprising but very much welcome, that if there was like such kind of like pipeline and protection, it will ensure that if something goes wrong or could go wrong, it could be like communicated to, of course, maybe in the case of national security, we might not want to allow, like public servant to go to the public, to the media, although I'm not sure I fully agree with this, but we could think of like building, pipelines where like members of the interest community could go to like NCIRA and be fully protected and be protected from reprisal, and like with all of the guarantees of anonymity to inform, the oversight authority, like to inform or answer of like issues and trying to find like solution report, like misbehaviors from like high level executive and those kind of things. And I think it was the first time that an an actor and actors of a national security like system in the world was flagging whistleblowers as a solution, a way to move forward, a better and a more like efficient community. Until then, often like whistleblowers were like presented as, traitors, the worst thing that could happen to a country. This is a narrative that been built, especially like by the US, but also by Canada, within and outside the insurance community. So I think it was like interesting shift, since nothing really like happened to my knowledge. But again, we don't know everything that happens within this ecosystem. But yeah, I think that was a interesting move forward.
The international economy is we could suggest that it's increasingly being moved towards large companies that are data driven, and their profits circle around the acquisition and particularly the processing of data. And with large amounts of data, the discussion about the computational methods for that data over the last 10 years, it's sort of, once upon a time, they were all described as algorithms, and increasingly they're being described as AI. But the constant amongst that discussion was that they were obscure, they were incomprehensible. Just what is your understanding of the roles for whistleblowers in helping us understand where that description of the interaction of humans with these systems as being ignorant of exactly how they work? How do whistleblowers help us understand when that ignorance has crossed over into negligence and then maybe even
Yeah,
malice?
no, absolutely. And so yeah, you mentioned like, we talk about algorithm and then AI, and then there is many other things. But I mean, those issues of like, corporate governance, because the kind of corporate governance, maybe not within the government, but still, they're not new. It always been there. They might be like amplified because everything in our lives are like, governed by those companies. Like there is no way you can be fully disconnected, because even your roads, like how you're gonna receive information is controlled one way or the other by like some corporate um, powers. And so, but we build those framework initially, and even in the financial sector, sometimes there's some reward for whistleblowers, etc. Because we know that companies will not come forward if they have to choose between like society and benefits like revenues. They will choose revenues. Maybe there might be a few exceptions, but they are like exceptions. That's why we've built this. I know in competition law we like gave our regulators powers to be able to like do inquiries and like open kind of like the door of what was happening. And we've seen like a lot of big companies kind of like like managing a market like the corn market or like the telecom market in Canada, like in Europe, in the US. And like over the years, whistleblowers allow us to unveil this, because if you're not like within, you cannot know. Sometimes you might be able to guess, but you cannot know exactly what is happening and how it's happening, what kind of decision are being made. And it was the case for like cartels in some like in some sector. It's the same, and it's even more, maybe more complex for like algorithms, because you don't know. Why do you see something on your Instagram feed or even your LinkedIn one, or like, TikTok? Is because it's AI. No, it's not AI. It's because someone, often a white cis dude, decided to design this algorithm this way and to amplify it a way or the other. And you know what? Some whistleblowers help us, and they help us to understand and to know that when a decision arrived to the table at Instagram, they had to choose of like going in one direction for future, but like it may harm kids. Like it's actually, it will harm kids, but also like, yes, but we're gonna earn like billions in ad revenues. Option A or option B, they chose option B, but we couldn't know. There's a lot of things we and some people are like, oh yeah, what we don't know doesn't hurt us, but actually, yeah, it does, and it does hurt our kids. It hurts like women, queer people, black people, those people online, and more, as we've seen with like TikTok in Romania, and how like Russia played the way like the TikTok algorithm work, and TikTok refusing to support the Romanian authority and to comply with this, led to a full hack of the Romanian presidential election that led to the cancellation, like the constitutional court had to like just cancel the first round of the election due to like that insane interference from Russia. So yeah, something that we might not know, might not understand. Yeah, it has an impact on democracy and also on our like personal lives, on the digital safety, but also physical safety, because we don't have like the digital world and the real world. No, we have one world and one contact that is like digital, and the both are like very like intertwined. And when something happen um, online, it has repercussion like offline. We know people being like bullied, or unfortunately, like we had various stories in Canada of like kids committing suicide because of what was happening online, what was like promoted or not promoted, that kind of like information. So yeah, that's why I think we need the help to unpack, and there is no other solution than to protect people within, because they're like in the now.
We'll take another question from the audience.
Okay.
Would algorithmic accountability be a way to ensure responsible moderation here and to prevent artificial heating? In case algorithms are proprietary, how would whistleblower protections be affected?
I'm trying to, yeah, we don't have the end, but I'm guessing yeah, it's
It's
affected.
TED. It's affected.
Yeah. Oh yeah. Okay. Cool. I just saw the. Um. So yeah. No. So thank you for the question, and hi. But the no, I do believe that that would help, and having that kind of like accountability, and it will help to also build documentation for in case of a platform not respecting the duty of care, for example, linking back to Bill C63. That would help to ensure responsible, like maybe yeah, responsible moderation, or like a more like healthy informational uh, ecosystem. So the issue is the algorithms are proprietary, and even though sometimes they might be like open source, but it requires a lot of work to fully like understand. It's not because it's open source that you can actually know everything and understand everything until like you put it in practice. And often like an algorithm is just one of the many complex pieces that come to play for a platform for like content moderation. There is like all of the tags and all of the rules of like what is allowed, not allowed, can be amplified, not amplified. The best example is X, formerly Twitter. It might be the biggest porn platform that exists, but people are not aware of because until now, and let's hope that maybe that part of the algorithm will not be changed, the X algorithm is very good at like splitting the platform between, not safe for work, like no minor content to the rest. I'm sure that most people never saw ever that kind of content in their life, but it is very much alive. So it's important, but because they're proprietary, that's why we need to have people from within that are protected, but also that we need to build the protection in our statutes to for those people, because if it's proprietary, it's going to be protected either by copyright, and very often like under the Copyright Act, under criminal code, you cannot like retro engineer. There is a few exemption for like security and stuff, but like it's very complex and maybe too complex actually to be implemented. And otherwise, it's protected by trade secrets, and there is no exemption, like no exception under the criminal code, as I mentioned earlier, for any kind of like public interest. For sure, maybe the crown would not, prosecute, but we we don't know, and we should not leave this to the decision of the crown to prosecute or not. It's an issue that is there in the criminal code, so we need to build like either to remove this, but industry might not be so happy, but at least to build exemption, because very often we didn't build algorithmic accountability. We're like very shy on AI, on platform, on so many things, because we're afraid that the US government will file a complaint under CUSMA or in front of the WTO. Well, even when we try to plead them for so many years, look what's happening now. And the thing is, for trade secrets, it's allowed under CUSMA. It's not prohibited. Like the US, they do have exceptions of the criminal provision, so we can we can. And the US doesn't seem to care a lot about CUSMA and international law and treaties at the moment. So maybe it's time for Canada to like move forward, move the needle on those issues, and follow other partners. We rely a lot on the US. It might be time to be more aligned with what's happening, in Europe and in other countries around the world, to protect digital safety of Canadians, because it will not come from the US government or American based tech companies who clearly have shown their true colors and support this administration, which is a bit quite concerning, not a bit actually, that is extremely concerning with the upcoming federal election.
So we're right on time, but I'd just like to ask one final question to leave everyone with, because if there's something I'm taking away from this, is that it's very complicated, and for someone who is looking at the prospect of blowing the whistle, it must be a very anxious and uncertain space. So I'm wondering if there is any resource or best practices even, or anything that you would recommend for someone who is looking at blowing the whistle to better understand if and how they could do so safely.
Yeah, so it can be very scary, and I do understand, because when you look a bit into this, you quickly understand that you mostly will not be protected if something bad happen to you. But like luckily in Canada, more and more there is like networks to help. Like there is the Canadian Whistleblower network that's here to like help people with best practices and stuff, like different website or like popping up. But I would say like the best thing, the best protection, what's even when we have a stronger regulatory framework, is anonymity. And for this, there is like some best practices is don't do this from like if you want to look for some information or like contact people, don't do this from any work related account or device. I would say even don't do this from like the usual Wi-Fi. Maybe because like, oh, it's like a movie. Yes, it's like a movie. Go to like a public on the public Wi-Fi, try to get like information. Never use like your email. I would say just create like a brand new email to connect with regulators if email is the only option. But more and more, they use like tools like journalists and even like some government organization sometimes use like platform that through the Tor network allow you to like provide anonymously some information. So yeah, to be very careful about this. Don't do this from your desktop and your work email, because for sure you will get caught. And yeah, maybe yeah, seek advice, seek help. But when you disclose, try to provide as much as information without providing information that could like identify you. If you're the only one having access to a file, it might be way more complex than if it's like something that has been around in the company. So this is the kind of things. But yeah, and the other opposite is anonymity is the best protection, but when anonymity is not possible, being highly public is the best protection, because then less thing can happen to you. Well, you're probably gonna lose your job, and so that's also something that a lot of people cannot afford. But yeah, so that's kind of like my quick recommendation, but there is way more coming up.
Wonderful. Well, thank you very much, and thanks to Dr. Florian Martin Barreto from the University of Ottawa for a wonderful presentation and some excellent comments afterwards. I thank everybody for taking the time to be with us this afternoon, and I look forward to seeing you all at the next webinar. Thank you very much.
Thank you so much. Have a nice